Just on an individual basis, what are some of the common reasons that veterans get stuck in this belief that their claim isn't strong?
Well, I think the number one cause is the slow process that these claims move forward in. The VA had a major overhaul of its claims process in a statute sometimes referred to as the AMA. The statute became effective in February of 2019. And moving forward in that whole process has been difficult for the VA.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Tony Francis Jackson.
So, welcome to Victory Over VA, your guide to understanding your VA disability benefits. So today, we're going to talk about the limiting beliefs that certain veterans have about their claims and what the response to that needs to be. So welcome, I'm Francis Jackson, this is Christian Terrison, and who are we? Well, we're lawyers at the firm of Jackson and MacNichol. Our particular specialty is representing veterans who are seeking veterans' disability and helping them get justice on their claims. And so who is this show for? Well, obviously it's for veterans of the U.S. Armed Forces of various branches. And more importantly, it's for those who care about veterans, whether it's family or friends or community support organizations. It's for anybody who's trying to help veterans, support veterans, or going through the VA disability process, which unfortunately can be both slow and emotionally painful for a lot of veterans. So here we're talking about veterans who are applying for disability benefits. We want you to subscribe to our podcast, and every week we'll give you some tips on what to do and how to do it. And with that, let's talk about this week.
All right, so we're focusing on the unfortunate limiting belief that some veterans have that their claim isn't strong enough to win, especially on an appeal. Overcoming that first denial to continue with the process can be tough. How often do you come across veterans who are hesitant to do another appeal because they doubt the strength of their claim or the seriousness of their disability?
Pretty often. I think many of our clients at some point in the process start down that mental road. And it's understandable. One of the sad things about the VA process is that the VA is badly understaffed in the adjudication area. If you go on the internet and look, you'll see that they are literally trying to hire thousands of people at this point because they have so many openings. So they're badly understaffed. They are only now getting into the 20th century in terms of making their systems computer organized and computer directed. As recently as 5 to 10 years ago, we would still get VA files that came in stacks of paper. They weren't electronic at all. The VA has made great strides in the last 5 years particularly in terms of getting their system computerized and computer directed, but they still have a long way to go in terms of being able to reach a point of quickly and efficiently processing claims. So that, combined with the inherent uncertainty of making any claim that's already been denied, trying to move that forward on appeal, is just hard for people. And lots of veterans get to the point where they're struggling with whether they should continue.
Just on an individual basis, what are some of the common reasons that veterans get stuck in this belief that their claim isn't strong enough?
Well, I think the number one cause is the slow process that these claims move forward in. The VA had a major overhaul of its claims process in a statute sometimes referred to as the AMA. The statute became effective in February of 2019. And moving forward in that whole process has been difficult for the VA. You know, they had to really change all their forms, all their internal processes. But it's also been made more difficult by changes in the legislation and the statutes, laws regulating how the process works, particularly the recent PACT Act that became effective not August of this year, but the previous year. So what the PACT Act did in particular was to substantially increase the kinds of claims that could be made and the kinds of claims that were subject to a legal presumption that if you showed fact A, then fact B was presumed. And so what that has done is to really create a logjam in VA case processing. The Board of Veterans' Appeals, which is sort of the central entity in the appeal process, was already behind, and now they're further behind. We're at a point where there are thousands of these appeals pending, and appeals that were filed back in 2019, 4.5 years ago, right after the law changed in February 19, are still pending for disposition in many cases. It's a very disheartening process for a lot of veterans to have these things drag on so long. And probably equally disheartening is that the process moves in a counterintuitive way. When we appeal a case from the regional office where the case was denied up to the Board of Veterans' Appeals, in many instances, the board agrees that the regional office was wrong in denying the claim, but they don't grant the claim. Instead, they remand the claim, sending it back to the regional office and telling them to develop further information, to get more records, and take various other steps to clarify the nature of the claim. And a lot of folks are very disheartened by that. They feel like they've already made the claim, they've waited a significant amount of time to have an appeal, either on the records or after hearing. They've waited for a decision after that, and now they're being told that they're not getting a final decision, either thumbs up or thumbs down on their case. Instead, it's looping back for more development. And the same thing happens at the Court of Appeals for Veterans Claims, where a decision by the Board of Veterans Appeals gets appealed to the court. Many people have the belief that the court is going to decide their claim, up or down, but that's not how it works. What the court is there to do is to ensure that their claim was fairly processed. So actually, the court is going to look at how the VA handled the claim and whether they treated the veteran fairly in the process. They are almost never going to decide that a veteran either gets benefits or doesn't get benefits. It's all about the process. And if you think about comparison to typical court processes in the civil system where our system of justice operates, whether it's a lawsuit over a dog bite or a car accident or whatever it may be, it works pretty much that same way in large part. The courts look at whether the process was fair, not necessarily whether the result was right, but whether the process was fair. Most appeals are about errors in the process. And that's the same thing at the Court of Appeals for Veterans Claims. The court has only a very limited ability to actually outright reverse a denial and order a payment of benefits. There are a few cases where they can do that. Those are the exception and not the rule. I've been doing this since 1992, and in that time I've had 2 cases where the court reversed and ordered benefits paid out of literally thousands of cases. It's just the way the system is set up, it is very difficult. I would say nearly impossible for the court to make a final decision in favor of the claim. It's because of the way it works, it's actually easier for them to make a final decision denying the claim, but to have a final positive outcome at the court is extremely rare, very difficult for the court to make things align in a way that they can do that.
Can you share a story of a claim that at first blush seemed weak, but went through the appeal process and came out successful?
I can. We had a client, let me call her Mrs. X for our purposes here, and here was the claim. She had a husband who died from a heart condition, which she said was related to Agent Orange. She made the claim, and the VA said that the death was not service-connected in the context of an application for burial benefits. The VA provides burial benefits, and they make a distinction between burial benefits for people whose deaths were service-connected and those who died for other reasons. And they make that distinction because Congress has authorized them to pay a greater benefit for folks whose death was service-connected. So they turned this lady down, saying that on her application for burial benefits, the death was not service-connected. Go forward 10 years, and the VA has been ordered now by the federal court to go back and look at certain Agent Orange-related claims, including heart claims like this lady's husband. And it looked like she'd already been denied. She went back to the VA. She made the new claim. They said, okay, the rules have been changed. Now heart disease is recognized as an Agent Orange-related claim. We can pay you. And they started paying her. She said, wait a minute. I made this claim 10 years ago. I'm entitled to 10 years of back pay. The VA said, no, go away. So we looked at that claim, and I frankly thought it was a challenge, a difficult claim. But we went forward with the claim. We made the argument that this case had been one where she'd applied for veterans' benefits for a spouse of a deceased veteran, and that they had turned her down for one of two types of benefits, but not both. The VA can pay the spouse of a deceased veteran under one of two programs. Either the veteran's death was service-connected, in which case you're eligible for what's called DIC, which is an acronym for Dependency and Indemnity Compensation. And when the death is service-connected, the widow or spouse can get a monthly benefit that's currently about $1,400 a month for that situation where they lost the spouse in a service-connected way. Alternatively, if the person served in a time of war, but the death is not service-connected, they can be paid a benefit, but it's a lower benefit, and it's dependent on their level of income. So above a certain level of income, you no longer qualify. And in her case, she had filed the application for both kinds of benefits. They had turned her down for the benefits based on her husband's service in a time of war, saying that she wasn't eligible because her income was too high. She had Social Security benefits and she was working. The combined income was too high. So we argued that the VA had never actually decided whether she was entitled to DIC benefits. They had only decided the pension claim. And of course, the VA said, no, we told her this death wasn't service-connected. Back on this burial claim, that's all we had to do. We said, no, the law is that you have to tell her that you're denying her on the DIC benefits and explain why. And you didn't do that. So we took that up to the court and we lost. The VA argued that their burial benefits letter was sufficient. And then we appealed that all the way up to the Federal Circuit, which is the next to last court before the Supreme Court. And at the Federal Circuit, we were able to convince them that, in fact, the VA had not ever made a formal decision as required on her claim for DIC benefits, and that she was entitled to, worked out by then to about 12 years of past due benefits. And the court actually ordered not a remand, but actual reversal and payment, which is the second of only two of those I've ever gotten. But that's, I think, a classic example of a difficult case that ultimately prevailed.
Are there particular conditions or injuries that you see veterans underestimating as part of their claims?
Well, it happens with a lot. There are too many to really list them all individually, but one place that happens quite frequently is with back claims. Many veterans who have difficulties with their back also have related problems, particularly in what's called radiculopathy, meaning nerves that are impaired by the back condition that cause symptoms down the legs, often from the hip down to the knee, sometimes all the way down to the toes. And very frequently, we see veterans who think that their back claim is not really a claim that's going to go anywhere, and that even if they prevail, they're going to get a relatively low rating because the VA has changed its back ratings around so that while it used to be that most back claims got rated at 40% in the VA system, now most back claims get rated at 20% in the VA system. But they overlook the fact that it is frequently possible to get the related leg claims also granted, and that if pain into both legs at a significant level is granted, that will give them a 50% rating rather than a 20% rating. So that's one that gets frequently low rated. Another that frequently gets low rated for in a similar way is diabetes claims. Diabetes claims generate of secondary conditions. The most serious ones usually is diabetic damage to the eyes. And again, lots of folks don't think of their diabetes a particularly serious claim when in fact it's causing damage to other organs and may end up being a claim that gets them a total disability rating when you factor in all the secondary conditions.
We're coming towards the end of the episode, but I just wanted to ask about the role of medical evidence, examinations, expert testimony, additional evaluations. What role can those things play in strengthening a claim that a veteran might feel is weak?
Medical evidence is huge. In many cases, the VA itself will get a medical opinion. Unfortunately, because of the way they do this, it's like many other government things. They try to get the lowest bidder. And what they do is they enter into contracts with companies that say they will provide medical opinions. And those companies in turn hire physicians who are not usually at the highest level of expertise in the area. And in fact, in some cases are not physicians at all. They're physician's assistants or nurses. And in some cases are not in a specialty that is even related to the condition, so that they might send a cardiology issue about someone's heart to a family practice doctor for review. So because the quality of the VA exams is uneven, some of them are excellent, don't misunderstand, but some of them are not. And because the quality is quite uneven, it's often very important for a veteran to get their own independent medical examination regarding the specific issue that's involved. Just to give you an example, a few years ago, we had a case where the lady was trying to get DIC benefits for her husband's death. He died of lung problems. He served as a number of years on submarines. We were able to get a cancer doctor to look at his records and determine that what had contributed to his lung problems was exposure to asbestos, which in turn causes or can cause serious lung problems. And that's what had happened to this gentleman. And that medical expert's report persuaded the VA and ultimately resulted in the lady getting a number of years of back benefits. So the medical evidence is critical. And what is most critical, in my opinion, is countering any bad evaluations that the VA gets. And sadly, as I said earlier, VA evaluations are truly a mixed bag. Some good, some bad, some kind of in the middle. But the bad ones will sink a case unless you get a good opinion from a true expert explaining A, what is really going on, and B, what's wrong with the other opinion and why. So critically important.
All right. Well, this has been another episode of Victory Over VA. Thank you for tuning in. Please be sure to subscribe and come back next week for our next episode.
And we'll see you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.